Call us to order. Start off with the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. You can go ahead and sit down. I'm going to give and then I'll get you sworn in. My name is Drew Smith. I'm the Code Enforcement Special Magistrate for the City of St. Cloud. My role today is to be an independent fact finder. I do not work for the city. I am here as an independent capacity. The way we'll proceed is we will hear from the city first. They will present their case and any evidence and testimony that they want me to hear. And when they're done presenting their case, if the respondent has any questions for the code enforcement officers to testify, you're free to ask them those questions. And then you can move right into presenting to me any evidence testimony you would like me to hear. When I've heard all the evidence, heard all the testimony, received all the evidence, I will render a verbal order here, and then I'll put that into a written order, and the written order will go out to the mail to the respondent, and you'll receive that probably early next week. With that, anybody who's going to give testimony today, if you'd rise and raise your right hand, I will swear everyone in. Do you swear from the testimony you give the truth, the whole truth, and nothing but the truth? I do. Thank you. And you can call our first case.
Case number 2019-02095, Southland Plaza Inn, Inc., Simple Pond. Location of violation, 924 13th Street, St. Cloud, Florida. Violation, Land Development Code, Section 3.19.3A. Description of violation, failure to prohibit but rather allowed new signage to be erected prior to obtaining a permit.
Good afternoon, Melissa Howes, Code Enforcement Officer for the City of St. Cloud. I am presenting this case for the property located at 924 13th Street. I don't believe anybody is here for this case, so at this time I would now like to enter into evidence the following items. A copy of the courtesy notice of violation hand-delivered to the business on September 23, 2019. A copy of the notice of violation sent by regular mail to the owner and the tenant on October 3, 2019. Copy of the notice of violation sent by certified mail to the owner and tenant on November 8, 2019. A copy of the statement of violation and notice of hearing sent by certified mail to the owner and tenant on December 6, 2019. Copy of the PowerPoint presentation, evidence of mailings, the code section in violation of, a copy of the deed to the property, and a copy of the cost incurred if the magistrate finds the respondent in violation in the amount of $215.40. On September 23, 2019, during routine patrol, it was noticed that new signage was erected at this location and no permit was on file. I went to the business and spoke to the manager on site and gave her a courtesy notice of violation to obtain a permit for the new signage by October 2, 2019. On October the 3rd, I checked the permit records and no permit had been submitted for approval. I then sent out a notice of violation to the owner of the property as well as the tenant at this location to obtain a permit within 10 working days. On October the 8th, I received a call from Roger with Infinity Signs stating that he was working for the tenant and needed some time to get his paperwork to submit for a permit. I gave him until October 28th to have the paperwork submitted to the building department and he agreed. On November 1st, 2019, I checked the permit records and did not see anything on file, so I called Roger with Infinity Signs. He advised me that he would have it in no later than November the 5th, 2019. On November the 8th, I checked the records again and nothing was submitted. I then sent out a notice of violation by certified mail to the owner of the property and to the tenant, giving them only 7 working days to comply. The owner signed for the mailing on November the 12th and the tenant on November 13th, making the date for compliance on November 22nd, 2019. On November 12th, I received a phone call from Ann Freeland with Liberty Universal Management stating that she gave the letter of authorization from the owner of the property to the tenant and wanted to know the status if they had submitted for a permit. I explained to her the steps that I had taken and the phone calls that I had received, and that I was not giving any other extensions, and there was nothing submitted at this time. On December the 6th, still no permit on file, so a statement of violation and notice of hearing was sent out by certified mail to the owner of the property and the tenant, which both were signed for on December 11th. The management company has made several calls to me checking on the status, and I advised each time that the property was not in compliance. On December the 10th, 2019, I took 3 photos of the signage in violation. On January 13th, 2020, and again today, January 15th, a reinspection was performed, and there is no record of a permit on file. 2 photos were taken on January 13th showing the signage is still erected. It is the city's recommendation that the respondent be found in violation of erecting new signage at this location prior to obtaining the proper permit by the time specified. The city would recommend that the respondent be given until January 31st, 2020, to either obtain the proper permit or remove all signage, or a fine in the amount of $100 a day be assessed until compliance is met. The city would also request that the costs incurred in bringing this case before the magistrate in the amount of $215.40 to be paid within 7 days of the written order by the special magistrate. That was, again, $215.40. And that concludes my presentation.
So is the banner sign down?
Nothing is down.
Oh. I'm looking at your January 13th photo. That
Oh,
one.
I'm sorry. Yes, it is down.
Okay.
But it was for the,
I understand
Okay.
there are multiple signs. I just, for my,
Okay.
to understand what the current condition of it was. wanna
and
make
if
sure that
you
I was
look a
seeing that
little
picture
closer,
accurately.
they have a sign in the window, which I did tell the management company. It says we are moving. So that's why I extended it until the 31st to give her ample time to go ahead and have the signage removed if the tenant didn't obtain the permit.
And so they can get a permit for the sign, right? Is there anything that you're aware of that makes this a non-permittable? It's just a matter of going through the process of getting the permit.
Yes,
Okay.
sir.
All right. And nobody is here on behalf of Southland Plaza or Simple Pond, correct? No? Okay. Based on the evidence testimony received, I find in favor of the city, find that there is a violation for erecting new signage without proper permits. Accept the city's recommendation of a compliance date of January 31st, 2020 to come into compliance with the code either by removing the signage or obtaining a permit. If not brought into compliance by that day, a fine of $100 per day shall run for each day the property remains in noncompliance with my order. We'll also order the respondent to pay the administrative costs incurred by the city in the amount of $215.40, which amount shall be paid to the city within 7 days of the date of my written order.
Thank you, sir.
Case number 2020-158, Fernando Holmes, PA owner, location of violation, 4601 Neptune Road, St. Cloud, Florida. Violation, Land Development Code, Section 3.19.11A. Description of violation, failure to prohibit but rather allow the electronic variable message sign at this location is not in compliance with the operational standards and brightness of the Land Development Code.
Your Honor, Jack Morrison for the city. Desiree Sanchez, counsel for the respondent here as well. Wanted to just sort of introduce Attorney Sanchez and also just give you a quick opening, if you will, so we go through the procedures. Obviously, Officer Neal is going to present you the evidence with regard to today's case involving this this particular matter. By way of a little bit of history, Ms. Sanchez has had some interactions, mostly in writing. I don't know if there's been telephonic direct with Attorney Manzares, the city attorney, but there's been some discussion back and forth about a request from Respondent's counsel to get information from the city with regard to the issues here today. We anticipate that the Respondent's counsel is going to be intent more focusing on things that are not necessarily factually evidentiary to today's violation, but more as to whether or not the ordinance was properly adopted and into effect on the books, as it were, and we would just make the opening statement that that argument is for another place and another time, if those issues are even relevant. We think the city is in good position with that, but we respect, obviously, council's position to look at that. With regard to the presentation from Ms. Neal, she's here with the evidence she has. She's available for any questions, certainly from the magistrate or counsel or respondent, as to regards to the evidence. But we think that the evidence will show there's a violation of the ordinance as is contained in the development code. And we just want a finding of a violation and a compliance date. I think in some of the communication between our office and Ms. Sanchez, there may have been an understanding that there were fines already in place. At least that was my inference in a communication from November of last year, and that's obviously not the case. So that's our position. Ms. Sanchez is here as well.
Okay,
So.
Ms. Sanchez, anything you'd like to open with?
Thank you, Your Honor. Good afternoon. Your Honor, we have, this all came about when my client received the violation. We're talking about April of 2019. Prior to that, we're talking December 2015. He was in strict compliance with, he got approval from the city for a sign, spent $38,000 on this sign. So on November the 15th, 2019, I sent a letter to the city requesting evidence and analysis on how they concluded that there was a legitimate government interest here. We were working in good faith. We just, my client, if they were able to prove that there was a legitimate government interest, my client would comply with everything that the city required. They did not do that. Instead, they actually gave me 3 letters rescheduling the hearing a few different times. They said January 22nd, they said January 8th, January 23rd, and then January 15th. It was not until yesterday that the attorney advised me that he would accept my email as a formal request for the information. That shouldn't have to happen. We're talking about November 15th, 60 days later, 59 days later, he tells me he's going to give me the information, or he'll accept my email as a formal request for the information that they need to show to evidence to support their conclusion that the sign needs to be modified. So the law firm has been a mess with all this. I was talking to their paralegal, to the lawyer. The lawyer yesterday sends me an email and states that if I want, because I just want to know, are there accidents? If we're talking about safety here, as to why my client needs to remove a sign or modify it, give me an accident report. Give me an analysis. Give me some sort of statistics that shows and supports their position that there's a government legitimate interest here.
Is it your position today that the sign complies with the code?
It does not, Your Honor.
Explain to me the legitimate governmental interest argument.
That's what I'm trying to get to here. So courts have shown that they take a case-by-case basis, where when they're talking about eliminating a use, they have to show that there's a legitimate government interest for eliminating that use. They have not shown that. There was a workshop, Your Honor, that Karen, who she works for, she owns the Academy for Kids, and she has the same sign. And my client, Fernando Holmes, went to this workshop where they asked the city, what is the government's legitimate interest? They failed to provide that information. They said it's safety, but then ended it there.
Eliminated? I haven't heard any of the evidence of the case yet, so some of these are,
Sure.
I'm not sure if some of these may be a little bit premature, but go ahead
Correct.
and explain, so
So-
when I hear it, I can listen to what you're
Absolutely.
focused on.
Well, my focus is that they failed to demonstrate that there is a government legitimate interest, that this sign will remedy any sort of safety issue that they
But what
state.
use, you said a use is being eliminated. What use is being eliminated?
Okay, I can advise you of every single violation. There's a lot of violations.
Okay.
So, can I come
When you
forward
say a
with this?
use is being eliminated, when you say a use is being eliminated, I think of a pawn shop being shut down.
No, Your Honor. So.
Help me understand what you're trying to tell me.
So this is a real estate brokerage, okay? This real estate brokerage depends on that sign. He's constantly advertising different homes on that sign. So what the code enforcement is stating here is that they want a dark background. I mean, again, I can go through every single violation. They want the sign to have a dark background. They require a minimum of 8 seconds of a display. The amount of time to completely change from one message to the next needs to be instantaneous. The change of message shall occur simultaneously with the entire sign face. The sign shall contain a default design that will hold the face of the sign at one position if a malfunction occurs. They state that now it's a requirement that there's no flashing lights, traveling messages, animation, transitional effects, or other movements are allowed. Brightness or glare shall be controlled to avoid distractions to vehicular traffic, pedestrian, and adjoining properties. Adjustments shall be made upon written request from the city. So all of these are modifications that they want to the sign that was approved back in 2015, and now they want it modified after my client has spent $38,000, has relied upon the city's approval. And what their position is that there's a government legitimate interest, that there's a safety issue, but they failed to demonstrate. So my opening is simply that they failed to demonstrate a government legitimate interest here. And when I asked for evidence so that we could, my client and I, because sometimes my client can be wrong, when I asked for that so I can review it and tell my client whether they were correct or not, they failed to provide it to me. And it wasn't until yesterday, 59 days later after my request, that they state that it would be costly and that they would need to pull all sorts of reports. Well, when they made the ordinance, they should have gotten all this information to support their position that there was a government legitimate interest. So my request should not be a burden to them. It should not be financially burdensome because they should have done their due diligence already. So whatever due diligence they did, they should provide it to us. They failed to do that. So today I have to testify is an expert in the field that has made signs for 30 plus years. I have Karen with the Academy of Kids who has not yet received the violation, although they state she's in violation. She's not in violation. I'm not trying to throw her under the bus, but she has the same exact sign as Fernando Holmes. So I just want them to prove that there actually is a government legitimate interest.
Is your argument today that the code enforcement must show a legitimate governmental interest whenever they enforce a code, or is your argument that the city must have legitimate governmental interest in adopting a code that infringes upon the First Amendment?
So what I'm saying here, Your Honor, is that with this particular case, because I can take a position of this ordinance is illegal altogether, but I'm not taking that because that is a deeper issue that's going to require the entire community's involvement. My client should be grandfathered in, okay? There is nothing to support the fact that my client should have to modify his sign. There is no evidence. They are required.
Okay, we can get there.
Okay.
Right now I'm asking you
Okay.
about the legitimate, because I'm a governmental attorney. I understand these issues.
Right, okay.
Is your argument that code enforcement cannot enforce a code that's in the books unless they can prove legitimate governmental,
That's correct.
legitimate governmental interest in the enforcement? Or are you saying that legislatively the city could not adopt it because they did not have a legitimate governmental interest in the adoption?
I would actually say both, Your Honor.
Do you have case law?
You know, it's interesting because I actually asked them to provide the steps taken in compliance with the ordinance. And that should not have been difficult to provide, and they didn't provide that. I looked at cases around Florida where other cities for adaptation of this sort of thing, and cities have shown that this
Adoption or enforcement? That's what I'm trying to nail down right now. Are
It's
you
really-
talking
but
about
it's
the
really-
adoption?
it's
It's
really-
important to me because I have no power today to say that their ordinance is unconstitutional. I can only
I agree.
interpret the ordinance as it's written and adopted.
Yes.
I cannot do that. Only a court can do that. All I can say is, does the ordinance say what they says it says? I can't say the ordinance was improperly adopted. So if your argument is they cannot enforce it unless they can show legitimate governmental interest, I need you to make that argument because I'm not sure I agree with it.
Okay, so they cannot enforce a ordinance that is not substantiated. And, okay, this is the
An
issue.
ordinance,
This is-
that's been properly adopted
Well-
is presumed valid until a court says
You're-
it's unconstitutional.
You're absolutely right, and let me take a step back here. So the community has an interest in the passing of this ordinance, okay? So the community was not notified, properly notified, of the hearing that was to take place on this vote for the ordinance. Both businesses went to a workshop that was there to educate the community about what they were trying to do. At that time, they asked the question of the why. They said, the mayor's office said, we are going to hold another workshop and a hearing on this issue. We will notify you. That was never done. So I recognize that we're likely going to have to sue the city on here in this matter to find this unconstitutional. We have mistakes made, like the law firm being uncooperative through this matter. We may simply have to do this. So if you're taking the ordinance by its word, okay?
I think I have to.
Okay,
I don't think
fair.
I have a choice, and that's why I'm being upfront with you, because I don't want you to make a bunch of arguments. There's nothing I can do. Because when it comes to the
Understood.
validity of the ordinance, I have to presume that ordinance is valid until the court says something different.
Right.
And so what we're talking
And
about
that's why I
today
asked for this
is the
information.
code enforcement action, and whether or not code enforcement has properly cited and prosecuted this case.
So
And you started off by telling me they don't comply with the ordinance, so you started off a step backwards.
they don't comply with the fact that, my clients were not, their due process rights were violated. So
Okay,
if
and we can get
that's
to that.
So, yeah, that's really what,
Okay.
that's my basis today. And when I asked for the steps taken for the ordinance, they decided the day before, and after 3 times of trying to get us really not to come today, they finally said the day before, and the attorney sends me, hey, the hearing is going to happen on January 15th. Very last minute, within the last few days. So this has been an ongoing issue. And their steps, we may simply just have to deal with this in a court of law if they're going to take a firm position that my client's in violation.
Okay. Yeah, and so I'm glad we were able to have the conversation, but so you know, so I can tell you where to focus. If you're focusing on what the council did when they adopted the ordinance, there is nothing I can do. That's beyond my jurisdiction here.
Okay,
Okay?
fair enough.
May I respond briefly?
Yes, sir.
I won't, just a few things. Appreciative of Ms. Sanchez's comments. Number one, to clear up a couple of things. The complexity of the fact that Dan Manzares, my law partner, and I handled duties for the city led to a miscommunication with Ms. Sanchez with regard to the date of the hearing, as one of our associates miscommunicated through a letter the wrong date. I clarified it by email. My only interaction with Ms. Sanchez was by email last week clarifying the hearing was today at 3 p.m. Initially, she knew that, and then there was a confusion, admittedly, due to a letter that went out on our office stationery from an associate that was working on behalf of my partner, Dan Manzares. The history of this, just so you understand, and I want on the record, really not for today's proceedings, but just to clarify, the request from Ms. Sanchez in November of this year was addressed to Ms. Sparkman and asked for certain information about how did the city get to a decision that led to the adoption of this ordinance that was adopted, as I understand, back in 2016. My partner, Dan Manzares, the city attorney, wrote Ms. Sanchez a page and a third letter dated January the 8th that addressed specifically the issue of the adoption of the ordinance, the grandfathering issue that stated that because the ordinance was dealing with an existing sign, not asking that the sign be removed, but only regulating the time, place, and manner in which the sign would operate, the grandfathering issue was not at issue. And the request for records that was propounded to Mr. Manzares, to the extent that it could be provided or responded to, was done so with regard to those businesses that at one time had been noticed and in violation. My understanding as we stand here today is this particular property owner is the only sign that's out of compliance on this order that I'm aware of as of this time. There were other sign violations in the past, going back to 2016, that had been noticed of and had received courtesy letter of code changes, things like the St. Cloud Church of the Nazarene, Academy for Kids, Gators Dockside, etc. But the letter from January the 8th, in part, talks about regarding your request for records, Ms. Sanchez. Provided is a list of all businesses that received notices related to the violation of the above referenced code since the City Council approved the reference code change. This list is the only document requested in your letter that the city has in its possession. With regard to your request for accident reports, the city does not maintain such reports by location, and therefore it is not possible to provide you the records as requested without the city performing extraordinary research at your client's expense to review all accident reports and locate the reports as you've requested with regard to accidents in the area where the respondent was located, etc. In the alternative, the city can provide you with a copy of all accident reports in its possession for a specified period of time. Please advise how you wish to proceed. It's my understanding that there was no further request for information other than an email late yesterday from Ms. Sanchez to Mr. Manzares that I was copied on that says simply, do you have my letter in your possession? I presume that's the November letter from Ms. Sanchez. If so, I'm looking for much more information. To which Attorney Manzares replied yesterday afternoon, if you're referring to the motor vehicle accident reports you requested, we will accept your email as a request for that information. As set forth in our letter I previously alluded to, the obtaining of accident reports related to the specific area of your client's sign will require extraordinary research by city staff, and we will ask city staff to provide an estimate of a cost of the research and provide it to you. Upon prepayment of the estimated cost, staff will commence the research. As an alternative, if you wish to have copies of every motor vehicle accident report in the city's possession for a specific period of time, please advise, and we'll provide you with an estimated cost to provide that non-exempt information from the city. So the city's fully in cooperation, trying to cooperate. The city is only seeking compliance with the code. There's a history to this, obviously, as there was much discussion, workshops that the respondent participated in those years ago. And now, as counsel has readily admitted, the current status of the code, this particular sign at issue is in non-compliance with the code. And so Ms. Neal was simply going to present evidence to show such fact, which has been admitted to, and ask for a time for compliance, and within the discretion of the magistrate. These issues about the enforceability of the ordinance, the adoption of the ordinance, we understand that those are not proper for today. We understand there's legitimate concerns on the other side, and we're respectful of those, but they're just not simply relevant here for today. So,
Okay.
Thank you.
Code enforcement?
Good afternoon. Pam Neal, City of St. Cloud Code Enforcement Officer. I am presenting this case for the property located at 4601 Neptune Road. At this time, I would like to enter into evidence the following items. Copy of the courtesy notice sent to the owner informing him that the City of St. Cloud had amended the Land Development Code on the electronical animated variable signs. The new code section at issue was effective on May 13th, 2016. Copy of the notice of violation, copy of the notice provided to the owner of the recent changes to the ordinance on prohibited lighting on April 19th, 2019. Copy of the notice of violation sent to the owner on April 23rd, 2019. Copy sent to the owner on April 30th, 2019, notifying him of the workshop on June 20th, 2019. A copy sent to the owner on August 15th, 2019, notifying him of the workshop on August 20th, 2019. A copy of the notice violation sent to the owner by certified mail and posted on the property and City Hall. Copy of the statement of violation notice of hearing sent to the owner by certified mail and posted on the property and City Hall. A copy of the letter from St. Cloud City Attorney to Mr. Holmes' attorney, Ms. Sanchez. A copy of the PowerPoint presentation, a copy of the affidavits of postings, the notice of violation certified card signed for, the statement of violation notice of hearing certified card signed for, copy of the deed to the property, copy of the code section in violation, a copy of the code section for non-conforming signs sent to Mr. Holmes on April 19th, 2019, a copy of the costs incurred if the special magistrate finds a respondent in violation in the amount of $360.10.
Has the respondent been provided a copy of all the evidence you're introducing? Any objection to the introduction by the code enforcement?
On February 11th, 2019, the Code Enforcement Department did a sweep of the city for electronical animated variable signs and found several businesses in violation. On May 12th, 2016, the ordinance for the sign code was updated and adopted. On June 8th, 2016, courtesy notices and a copy of the sign ordinance that pertains to the amended code sections went out to each business in violation, advising them that they were in violation and would need to make the changes needed to bring the sign into compliance. All businesses made the necessary changes to their signs except two. These two businesses went before the council on June 23rd, 2016. Code enforcement was directed by staff to place these two cases on hold until further notice. On April 19th, 2019, Mr. Holmes was notified with a courtesy notice, a copy of the ordinance number 2018-29, recently adopted code provision 3.19.11, and a copy of the section 3.19.8E was sent to Mr. Holmes informing him that his property was in violation of the newly adopted code. On April 23rd, 2019, Mr. Holmes was sent a notice of violation and a copy of the recent adopted code section, giving him 60 days from the date of the notice to come into compliance, or the property would be subject to a fine of up to $250 a day. On April 30th, 2019, the owner was sent a letter informing him that the ordinance number 2018-29, notice of prohibited lights, had been placed on hold until further notice. A workshop will be held on June 20th, 2019 at 6 p.m. at St. Cloud City Hall Council Chambers. On August 15th, 2019, the owner was sent a letter informing him that there would be another workshop on the EVM signs on August 20th, 2019 at the St. Cloud Community Center. On October 29th, 2019, I went to the location to hand deliver a certified notice of violation. The owner's son refused to sign for the notice per the owner. I explained that if the notice was not signed for, that I would post the property and City Hall. He still refused. So on October 29th, I posted the property and City Hall with a copy of the notice violation. I also sent it through the mail, which was signed for on 11/1, and I took 2 photos. On November 13th, the reinspection was made at night, and the sign was still in violation of the brightness. The flashing lights, traveling message, animation, transitional effects, or other movements, and changing more than once in 8 seconds. I took 2 nighttime photos and 2 nighttime videos. It's so bright that my camera could hardly focus on it. On November 20th, a reinspection was made, and the sign was still in violation. On November 27th, the reinspection was made, the sign was still in violation. I took 1 video. On December 5th, a reinspection was made. The sign was still in violation.
Ms. Neal, what am I looking at here? 'Cause
That's
new
the
video's
sign.
going. Okay.
And I'm
Is that the
quite-
video you just referenced or a video you're about to reference?
That's what that's what I just referenced a minute ago. Yeah, that was the, yeah. And now he's fixing to show you for December 5th. I have 1 daytime video and 1 nighttime video. And that's like from the corner by the police department. That's a long ways away, and it's that bright. On December 9th, a statement of violation and notice of hearing was sent by certified mail and posted on the property and City Hall. I took 3 photos. Yeah. Okay, that's the 9th. On December 17th, the reinspection was made. The sign was still in violation. On December 26th, a reinspection was made. The property was still in violation, and I took a photo at night. That's a photo. That's how bright it is. On January 8th, a reinspection was made, and the sign was still in violation. And I took one daytime video and one nighttime video. That was the 5th. On January 13th, the reinspection was made. The sign was still in violation. I took a daytime video and a nighttime video. I don't know. Did he play them already? Okay. The respondent is here. Would like to talk? Okay. It is the city's recommendation that the respondent be found in violation of allowing the electronical variable message sign and to not be in compliance with the operational standards and brightness of the Land Development Code at this location, and to have the sign in compliance by January 31st, 2020, or pay a fine of $250 a day until compliance is met. The city would like to also recover the costs incurred in bringing the case before the special magistrate in the amount of $360.10 to be paid within 7 days of the written order of the magistrate as well. And that concludes my presentation.
Don't go anywhere. I have a couple of questions for you, and then I'll allow cross-examination if there is any. Actually, go ahead. Do you have any cross? I'll let you cross. And
The video that you provided us right now, if you were to visually look at the sign without the video, does it look different or does it look exactly the same?
At night, it's bright.
That's not my question. So my question is that if you were to just visually look at the sign, so we visually look at that screen right there, versus you videoing that same sign, does it look exactly the same or does it look different because we're using video?
During the daytime, it looks the same. At nighttime, it does not.
Okay. So, and what you provided here mostly is the nighttime.
Correct.
Okay. And so same thing with photo. Does the photo of the sign look exactly precisely how it looks without taking the photo if you visually look at it?
During the daytime, yes. During the nighttime, no.
Okay. And are you aware of all correspondence going to Mr. Holmes during this entire process? So did you personally send out the correspondence is really my question?
No.
Okay.
My supervisor, Sparkman, I sent out the notice violation and a certified notice violation. The workshops and stuff, my director, my supervisor, Terry Sparkman, sent them out. And they're all copies with her names on it as evidence to you.
Okay. And are you aware whether the law firm sent me correspondence as well? So can you say whether the law firm sent me correspondence?
I can.
You
I've
can-
got copies of them.
So you can testify to the fact that I received, that you are certain that the law firm mailed me correspondence? You
Oh,
can
not
testify to
mailed.
that fact?
Not mailed, no.
Object to the form of the question, I think it's confusing.
Yeah, emailed. I've got the same as that Jack.
I don't have any more. Actually, if you can give me one moment, I just want to make sure that my client does it.
Okay.
Okay. I have no further questions.
Can I just follow up on something, clarification for Ms. Neal, just stand at the microphone. Okay. Please, at the microphone, please. Stand. All right. With regard to the sign, how many times have you been out to the subject property, would you say, in the past 6 months? How many
Oh.
times?
20, if not more.
So you've had a chance, have you had a chance to view the sign during daytime and nighttime hours both?
Yes.
Do the photographs and the video that you presented for the special magistrate here today, do they fairly and accurately depict the sign as consistent with your time that you've been out there to independently view the sign?
Yes.
So these photos and video are mostly accurate?
Yes.
You recognize that it's video and that
Right.
it's a photograph, which is different than human visual direct perception.
Right.
But they fairly and accurately depict the sign.
Yes.
In terms of brightness,
Yes.
in terms of the changing of the sign,
Yes.
and what's being portrayed on the sign, what's being visually transmitted?
Yes.
Okay, no further.
Before you go anywhere, between Ms. Sanchez and Mr. Morganson, they asked the questions that I was going to ask you also, but I do have one more. Is it your opinion, from your personal observations of the sign, that the brightness at night causes distractions to vehicular traffic, pedestrian, and/or adjoining properties?
Yes, sir.
And what is the basis for that opinion?
Well, it's when you're driving down the road, it's like, it's so bright it glares. I mean, when you go at night, it's just obvious. And I've also had the chief of police come to us and say something to us about it being bright, and several officers.
Right now, I'm just concerned with your personal observations.
Okay, well, my personal, yes, at night, it's a very bright and glare.
Okay, thank you. Anything else from any other witnesses from the city? That's about it.
No, sir.
No?
Your Honor, I think that for purposes of today, we are definitely going to be pursuing legal action on a separate note. But what I would ask, Your Honor, is that today, we've been working in good faith since day one. My client has been actively involved. The community has been actively involved with trying to figure out the whys around here. And he's not trying to be vindictive. He's not trying to just go against the city just because. We have a 2015 approval for the same sign. He invested $38,000. I have the gentleman who actually made the sign and makes signs for all sorts of people who get approval, and he ensured that it was approved. We worked in good faith with the firm. I was in touch with Ms. Sparkman and Ms. Neal in trying to figure out how can we figure this out, because there's no justification. They're just simply, without, of course, testimony from the officers and without action reports and what have you. We really don't know their rationale. She can speak about her personal opinion of it, of course, Your Honor, but we're working in good faith here. We want justice. We want to make sure that whatever reasonable standard is, if they did use a reasonable standard, okay. But it's our position that they didn't, and we'd like for Your Honor to take into consideration that we're working in good faith with them. We want to, I recognize that right now, that you have to, yes, there's, fines involved when you're in violation of an ordinance. I recognize that there has to be a deadline. I would ask that Your Honor will actually allow for at least 120 days for strict compliance on it. Of course, we're, go ahead.
For what purpose? Give me the
Because
reason.
we need to get additional information from the city, and they have.
Is the
while-
city asking them to turn the sign off? Is that what you're interpreting?
No, they're asking for they're asking for so many modifications that it's going to cost my client an additional $38,000, and I have the gentleman.
I would like to hear from the gentleman who installed the sign.
Sure. And he has actually testified.
Jim Thomas.
He's actually testified in other cities for the
Good.
same sort of thing. So he's,
Are
I
you?
don't know if you want testimony or if you just want to hear from.
Well, if you would have testimony you'd like to offer, I'll let you go ahead and offer your testimony first. And
Was the gentleman sworn? Were you sworn?
Yes, he was.
he was.
Okay,
Yeah, I
thank you.
did my hand and everything.
Thank you.
So if you have testimony you'd like to present, I'll hear that first, and I'll give city an opportunity for cross. But I do have some questions of my own. All right, Mayor, you
Absolutely.
may ask them already for me.
All right, I'm Jim Thomas. I own Ad Systems, moved to Fort Myers from Iowa in '86, and have been in this business since '82. I've seen a lot of these changes in codes over the years, and typically, the city takes a position that it's a safety issue, and that's the reason they have to have more control. So many governments want more and more control. The situation's always the same. They have no evidence that they cause accidents. They have no evidence that the remedies they offer to make them safer actually do make them safer. And you want to add something?
No, go ahead. Go ahead, Jim.
I will make a point, if you invite me to make the comment. The issues that are being presented to the magistrate go to the adoption of the ordinance in the city's perspective.
He asked
I
me-
understand.
he asked me to.
I'll allow it to continue. For he's just giving an introduction and then helping me understand the issue. So I'll allow him to continue.
All right.
Anyway, so I've seen litigation with municipalities that lost because they couldn't demonstrate that it proved a legitimate government interest. Most of the times when the codes are changed, the people that already have electronic signs are grandfathered in because they bought their displays under the old code. And it would be analogous to somebody saying, okay, I'm buying this building, I want to be able to put a barber shop in it. I load it up, make everything for a barber shop, and after I get it running, you tell me you can't have a barber shop anymore, you got to turn it back into a garage. So that's just some of the history I've got. When it comes to it, just listening to things here, it seems to me that the people that have electronic signs, their probably course of action is going to be to litigate the city because the city cannot demonstrate that this new code serves a legitimate government interest. And they cannot demonstrate that there's any safety hazard whatsoever. The letters that our attorney sent asking for documentation of accidents was only asking for, how did you come up with the idea that these are unsafe? Somewhere, somebody got an idea that these weren't safe, to go out and take away the rights of the public. So somewhere, somehow, they got documentation, or they made it up, or they took it from another code that they didn't understand, that somebody else did.
Can you just provide to the special magistrate information on the actual sign? So what would be the cost of something, modifying, and I'm
Well-
sorry, let me retract. Have you seen the violations, the list of violations?
Yeah, I've seen the
Okay.
list of
And
violations.
so how much would something like that cost Mr. Holmes in order to modify to meet their requirements?
They're not, it wouldn't cost him anything. But they're asking him to use the sign in different ways than it was designed. The nighttime brightness is fixable. There's a day-night dimmer. So that, to me, looks like the biggest problem. But it would be interesting to see the government demonstrate how holding it for 8 seconds cures a safety issue, or turning it off at night cures a safety issue, or using it so that it doesn't roll on a message and roll off a message, how that cures a safety issue. So that'll come in litigation afterwards. I'd probably not place for it today, but that's just the background and information. And these are all over the country. The Department of Transportation is the biggest user of electronic displays in the country. If you ask who the staff called, the DOT, to see if they're safe, because they're worried about safety, they won't have a name. None of them ever do.
Have you ever seen video displayed on an FDOT sign?
I don't believe I have.
Do you think video is different than static messaging?
Not as far as safety issues, no. As far as all the surveys and tests that have been run, there's been no correlation between video and static messages. The DOT typically has a static message over the highway and the interstate. However, when they take the smaller displays and put them in real congested areas, they move the frames fairly quickly because they have to get out a whole message, and they got a small display. So, no, I haven't.
I'm sorry, I don't mean to cut in.
Go ahead.
You stated that you're familiar with the code violations that have been cited. Your testimony was that it would be zero cost to actually come into compliance with the notice of violation. Practically speaking, what would be required? What's the process for curing the violation? I understand you disagree with the ordinance that it's based on, but what would be the
Appreciate that.
process? What would be required to be performed to the sign to come into compliance with what code enforcement has cited?
All the programming would need to be changed. There's a lot of nice, cute animations that he's able to do now that he wouldn't be able to use anymore. So the power of presentation is inhibited somewhat. The signs are designed so that they do get attention and get read.
Practically speaking, those things that are needed to be performed to the sign to do what code enforcement has cited, or to cure what code enforcement has cited, what time frame would be required, again, for the performance of those things? I understand the underlying dispute. Property owner wants to do what property owner wants to do. City wants to do what city says the code says. I'm familiar with those disputes. They happen in every code case. But the reasonableness of time required to perform what needs to be done to get the sign in compliance, if that's what the respondent chooses to do.
Yeah, that's a programming issue, and it would kind of depend on,
Is it programming that occurs on site, or is it programming that occurs off
this
site?
case, it's on-site.
And is it a matter of, is it clicking and moving, turning things on, turning things off, changing parameters, or is it writing code?
The latter, yeah. It's
Okay, so
just
it actually is
clicking.
writing code for.
No, it's clicking.
It's just clicking and
Yeah,
turning on, turning off, changing
yeah,
parameters.
right.
Matter of hours or matter of days?
Probably a couple days. They'd probably feel better if I said 120 days, but
It's okay. It's okay. The idea is to be honest. It's fine.
Okay,
So-
those were the questions that I wanted to hear.
Yep.
So if you have anything further, you're welcome to proceed.
Okay.
If there's
No.
any cross, does he have any cross?
There's no
Okay.
cross. No cross.
Ms. Sanchez, any other witnesses you'd like me to hear from?
No.
Okay.
Just a follow-up, if I may, Your Honor. If I can do so in concluding the city's position, if that's all right?
Yes, go
I'll be
ahead.
brief, thank you. Just want to confirm, as was stated at the outset by Ms. Sanchez in her opening, respondent really didn't dispute that they were not in current compliance with the Land Development Code as it's currently been adopted and is seeking to be enforced. Mr. Thomas has confirmed in his expert opinion that the sign can be brought into compliance within just a couple of days. It sounds like with obviously just some focus on the areas, which are several under the Land Development Code. I certainly was sensitive to the fact that Your Honor identified element G, the brightness, glare, and the distraction to traffic, pedestrian, and adjoining properties as somewhat being an element that would be objectively viewed, and you would need some, subjective information on that. But I think the evidence was clear that the static display, the transitioning, and the brightness and those things are all outside of the scope of the standards that the Land Development Code has adopted. So we would simply ask for a finding of noncompliance, and whatever the magistrate's time for compliance, we would defer to your discretion, obviously, the city would like to recover the costs that have been incurred in this case, which stand at $360.10, and which costs could have been less, candidly, but related to the service items that Officer Neal mentioned at the time of her initial attempts to serve the property owner and was turned away. So I point that out only for example. But the city is otherwise rests and looks for a finding of noncompliance. Thank you.
Okay. Ms. Sanchez, anything you'd like to offer
just-
for close?
Yes, I would just like that, that the administrative costs not come into play here. First of all, they don't provide sufficient information to support that. But secondly, we have been actively working in good faith here. And as I stated, I've been in communication with everybody here in order to work together, not against them. So this should not penalize my client. I recognize that my client's going to have to get in compliance to avoid the fine, and then we can litigate after. But I ask that you not penalize him for with the administrative fee.
Okay. Based on the evidence testimony presented, I will find that there is a violation on the subject property for the reasons stated in the notice of violation and for the reasons presented in the testimony, and not rebutted or refuted by the respondent. I do find that the violation exists. I will give a little bit more time for most of those violations than what code enforcement has asked for. Code enforcement has asked for compliance by January 31st. I do recognize there may be a scheduling issue and there may be some time involved in getting that list taken care of. So I will give until February 15th to cure all but one of those issues. And the one that I still want to see, and this, my order will say this, cured by January 31st, is the nighttime issues, because I recognize the difference in video when it's on a cell phone and light being emitted from the cell phone, but there's a lot of glare there, and I think the expert alluded to it. There's a problem with the nighttime display of that sign. I've seen enough of them. I've seen videos of enough of them. There's an issue there, and that needs to be corrected, because you can argue in court all you want over the overall safety impacts of moving pictures on signs, but when it's at nighttime and there's a flash, it blinds you. And that does cause accidents. And I don't think anybody in this room is going to disagree with me on that. So I am going to accelerate the compliance date for the nighttime issues and to come into compliance with and I guess it's the hours of operation as it's presented in the code, one, but two, and it is a very simple fix, to correct that dimmer that occurs at night. And if it's on a timer, maybe the timer's off. If it's just not functioning properly, but to get that fixed so that when it's dark outside, that sign isn't blinding people. As I already said, February 15th. I understand and am sensitive to the arguments related to, I will finish up. If not brought into compliance, if either of those issues are not brought into compliance by the date in which I'd set, so again, January 31 for the night display and February 15th for all other issues. I'm actually going to stagger my finding as to potential fines. These are not actual fines until the time runs for compliance and you don't meet it. But if that nighttime issue, the nighttime display, the dark display, is not resolved by January 31st, I will, at a subsequent hearing, consider additional fines of up to $250 per day. And that is based on my finding that of the violations that are cited, that one is the greatest threat to the public. And then February 15th, or the February 15th compliance date, if those items are not resolved by that date, $100 per day. But I find that nighttime display issue significant. As to the administrative costs, I'm sympathetic to the arguments, and I want you to understand that administrative costs are not meant as a penalty. And every single case that comes before me, the city presents their argument for administrative costs, and they document the time that they spent. And the statutes allow it and allow me to award it, I don't find anything out of the ordinary in what they presented in their number of hours, especially given the arguments and testimony that were presented to me today. It is a complicated issue. There was a lot of evidence collected in this case, so I don't find anything out of line in that, nor was an argument made that anything was out of line in that. And if it's just a matter of, well, we don't want to have to pay it, we don't want to be penalized, it's not meant as a penalty. It's meant so that the rest of the taxpayers in St. Cloud aren't paying to make sure people are complying with codes. That's a cost, just like a court cost. If I get arrested, I got to pay those court costs so the taxpayers aren't paying for my judicial process. And I understand you don't think you don't want to be in this judicial process. I understand all of that, but as we sit here right now, I have not heard an argument to cause me to waive those administrative costs in this case. I will consider additional time to pay them, though, if you would like to ask for that, because what the city has asked for is 7 days to pay the $360.10. I recognize you may be paying the sign consultant to come out and make some changes that you'd rather not have to pay for right now, so if you'd like more time to pay those administrative costs, I would certainly consider it.
I don't think it's an issue.
Okay. Then everything I have said, I will boil down into a order. Ms. Sanchez, if you could provide me with a business card, if you have one, if not, your email address, and I'll make sure that as soon as I sign that order and put it in the mail, that you get a copy of it.
Sure.
And so that order will come in the mail, the respondents will receive it. I'll make sure Ms. Sanchez also receives a copy of it, and I appreciate the arguments that both of you are making, and I appreciate both of your professionalism today. I think she's right, and so I'll let her make a copy before I leave today. And I appreciate your sign. I'm sorry I forgot your name, but I appreciate you making the trip, and I'm sure your clients do too. Thank you.
I don't need that. Ready for
You ready?
new business? Yes, sir, of course.
I was just waiting for the room to clear. You ready?
Yes, sir.
Unfinished business, none. New business, request for reduction of fine liens under 50,000. Case number 2017-1086, Jeremy Attican, owner. Location of violation, 1121 Wyoming Avenue, St. Cloud, Florida. Original hearing date, May 17, 2017.
Your Honor, Jack Morrison for the city. This is a request for reduction of fine lien settlement. The case dates back to 2017. The property at 1121 Wyoming Avenue, there were a number of different areas in violation in which compliance was to be attained on or before May 30th. Compliance was finally achieved on June 30th. So 30 days in which a $100 per day fine had accrued. So a $3,000 total fine had accrued. The respondent and the city manager have agreed on a settlement of a $500 payment to be paid within 30 days of approval by Your Honor in order to settle the matter. And it's been There's a duly executed,
Yeah,
signed
I've seen it.
agreement. So we're asking for your,
I will approve as agreed to by the city, with the caveat that if it's not paid within 30 days,
sir.
that it revert to the original number.
yes, sir, exactly, thank you.
Request for reduction of fine liens under 50,000, case number 2019-1845, Clara Johnson, owner, location of violation 721 McKay Street, St. Cloud, Florida. Original hearing date September 18, 2019.
Yes, Your Honor, Jack Morrison for the city. This respondent, Ms. Johnson, has submitted a request for a reduction of fine, which was accepted by the city manager. This was a case that was heard recently, it was back last summer, I believe, or actually heard in September, dealing with grass and weeds. Compliance was reached in December of last year. There was a 73-day accumulation at $100 per day. Ms. Johnson is not here. She requested that she appear via the communication that I think is part of your
Yes, sir.
packet. And so we obviously had no problem with that. She's asking for, and the city manager has accepted, recommended rather, a settlement of $440.10 to settle the matter. So the city's fine with that if it's approved by Your Honor.
Yes, sir, and I will approve that as set forth in the agreement with the city, with the caveat that if it's not paid within 30 days, it will revert back to the original amounts.
Thank you, sir. Nothing further.
Next scheduled meeting, February 19th, 2020.
Anything else from the city?
No, sir.
We are adjourned.
Thank you very much.